SJC-13710, Tody Service, Inc. versus Liberty Mutual Insurance Company.
Attorney Caffarelli.
May it please the court, and good morning. I'm here this morning, Ralph Caffarelli, with Attorney Michael Ocalita from my office, and we're here on behalf of Tody Service. In this case, it's a case, frankly, that arises out of a terribly tragic incident that happened on March 1st of 2016, when Bradford Castler, who was an insured of Liberty Mutual, was driving his motor vehicle in Newton, and he was going at a high rate of speed and lost control of his vehicle, and the vehicle penetrated Sweet Tomatoes and killed 2 people inside and injured 7 others, struck 2 other vehicles along the way. At the time, Newton police obviously arrived at the scene, and they needed to have somebody tow the vehicle, which was embedded in Sweet Tomatoes. Tody's was the vendor that they used for their towing services. They called Tody's. Dave Donahue, who's been in this business since he was a kid, came to the scene, and through a painstaking process of trying to extract the vehicle and assist with the recovery, which took hours, the vehicle was eventually removed from the interior.
So
and
why does Liberty Mutual have to pay for these costs?
The reason Liberty Mutual has to pay for these costs is really threefold. One is they promised, on the doctrine of promissory estoppel, they promised to do so. Under the facts, what happened here was...
Okay, so that's one.
1, promissory estoppel. 2, quasi-contract. And 3, there's a statute, chapter 159B, section 6B. So there's 3 bases upon which we are seeking recovery: promissory estoppel, quasi-contract.
So let's start with the statute. What's your best argument that Liberty Mutual, under the statute, is on the hook to pay Tody's?
Well, first of all, Liberty Mutual, they insured the vehicle. The vehicle was an involuntary tow. It was brought to the scene
But what words in the statute give you a right to go after the insurer of the vehicle that you're holding on behalf of the police?
The statute itself provides that there's a maximum recovery in a situation where a vehicle has been involuntarily towed.
Against the insurer?
Against the owner, and in this case, on the unique facts of this case, at the end of December, the year of the incident, Liberty Mutual went there, finally totaled the vehicle. Thereafter, they asked their insured to sign over title. The Liberty Mutual's insured, Castler, sent the signed title to Liberty. Liberty paid them $13,000+, and at that moment, in early January, Liberty Mutual itself became the owner of the vehicle. Those facts are supportive of the fact that this statute would provide for a recovery, which under certain circumstances would be limited. It's been defended.
Well, no, what the statute says is that you have a lien for those costs up to $35 a day.
It does.
And that you can enforce that lien through the statutory provisions applicable to lien enforcement. The statute does not, you'll concede, expressly create a cause of action other than that, does it?
I totally agree with you, Your Honor, but the mechanism that would permit the lien to be enforced would essentially allow the recoverer, in this case, Tody's, to only get a sale of the vehicle, which we know was totaled. The vehicle was worthless. It had a salvage value of $3,000.
So you're unhappy with the remedy provided in the statute?
Unhappy in the sense that it doesn't allow us to get anything above the value of the vehicle, which in this case...
So the statute lets you get to the value of the vehicle, which is what Liberty Mutual has tendered?
I'm sorry, I didn't hear the end of that, Judge.
The statute, you're saying, allows you to recover the value of the vehicle, which is what Liberty Mutual tendered.
Actually, the statute does not preclude you, it does not limit your recovery to the value of the vehicle.
Right, but
And
it
in this
only
case-
allows you to recover the value of the vehicle.
The statute allows you to not be limited to the recovery of the vehicle. And that's what the statute permits. And in this case, that was what we were seeking. We were seeking more than the value of the vehicle. We were seeking the actual storage charges for the vehicle for the 10 months it took Liberty Mutual to go and appraise the vehicle. At that point in time, Castler owned it. Thereafter, in January of 2017, Liberty Mutual owned it for the next 2 years until such time
But
as
your
the case.
statutory remedy is the price, is the cost of the vehicle, right? So the other two, tell me about Quantum Merowit.
Quantum Merowit, in this particular case, it's Liberty Mutual's cornerstone for this is the Dines case.
Yep.
Dines case was distinguishable on many grounds. Most importantly and significantly,
Well, what, just besides Dines, what is the recovery for somebody who's benefited another person?
the recovery is the value of the benefit conferred.
Okay, and how could the value of the benefit conferred on the owner of the vehicle be anything other than the value of the vehicle?
Because in this case, the vehicle had absolutely no value except as evidence. This vehicle had evidence in the criminal case and in the civil case. That's why it was being held. That's why it was being held in a secured facility. That's why it was being held indoors. And all of that time, there's a cost incurred to all of that. And if
So
you look at,
is an evidentiary value different than the value of the vehicle?
I think so. I think it has to be because in this case, the vehicle had no value whatsoever as a vehicle, but it contained within it information, for
No,
instance, about the.
I know you want to get around it, but Liberty Mutual paid to the defendant in this case whatever the total loss value was, $13,000, right?
did.
So why isn't that the metric of the value? You're saying, I get your argument, I get your logic, that for the criminal case, there was this evidentiary value to the car, but we're talking about for purposes of the statute.
But it wasn't just, that vehicle didn't have just value for the criminal case, Your Honor. There were civil cases which were absolutely certain to come out of this tragedy, and they did come out, and Liberty Mutual was aware of that. Don't forget that in the early part of this case, when Mr. Castler reported this the very first time, he talks about this in terms of a sudden acceleration. He says that the vehicle took off from him. In those circumstances, Liberty Mutual is going to be saying, and they did say, this vehicle may have had a defect.
Sure, but
that had
in
to
the
be
end,
explored.
it may have had evidentiary value for the criminal case, and it may have had evidentiary value in the civil suits. But Liberty Mutual's exposure in the civil suits is bounded by the policy, correct?
That's correct.
But so how could, even if we were to accept the idea that evidentiary value is recoverable as the measure of damages for a quantum Merowit claim by you, how do you get to the number you're coming up with? Because they were never going to be exposed to that.
Well, the value, the evidence that we're talking about was the evidence of the vehicle itself. The value had to be in storing the vehicle and preserving it for litigation. The Liberty Mutual points out in their brief, and they make a point of this throughout, that they had tendered their policy. But there's no evidence in the record of an actual tender. They tell us.
I think they just meant they reserved the policy limit. I had a question about that too.
Well, and my understanding of a tender is, and there are circumstances where it occurs, where they actually send the money to the court, and we've all seen that. They didn't do that. The second thing about Liberty Mutual was they said that they had made a decision, and they had talked about in the civil case, which was taking place on a separate track, they said in that case they were going to agree to liability, perhaps amend their answer to the complaint to agree to negligence. But the summary judgment record does not show that they did that. And so what ends up happening is the civil case is basically put on hold. If you read the docket in the civil case, the Miele case is the primary case of the one involving one of the two people that died. You read that docket, you can see Liberty Mutual's attorneys who represented them under the terms of the policy, they were pressing to make sure that Mr. Castler did not have to produce any discovery in that case. They actually took an appeal from a judge's order ordering the discovery to occur, ordering his deposition to occur. They stalled that case as long as they could, and then it was only after the Castler criminal case was, he was found guilty, that the civil case is resolved. But the whole while, Liberty had an expert witness that they had on retainer.
Liberty didn't need to pay you. The prosecutors were insisting that the car be preserved there. So Liberty didn't have to do anything to keep the car. The government was insisting you keep the car, and you have a contract with the government.
Unfortunately, Judge, there was no contract with the government. There was no.
They asked you to tow the car and keep it. Liberty didn't have to pay for something that the government was insisting on, does it?
Well, as the owner of the vehicle, I would suggest that they did.
But you're saying that the value to them is the evidentiary value of saving the car.
Correct.
But they get that for free because the government is insisting on the car being retained.
I don't think so, Your Honor.
Why not?
Well, I think
They
that.
couldn't, and by the way, they couldn't, even if they wanted to not keep the car, they had no say in it, right?
Liberty Mutual in
Did the
their
government
opposition.
say to Liberty Mutual, we're going to throw away the car if you don't want it? No.
Liberty Mutual in their opposition brief, they made several points, and one of the points that Liberty Mutual was making in this regard was essentially that Liberty Mutual had the right to do what they did, and that what Liberty Mutual did, though, was they explained, and they tried to implead, late in the game, tried to implead the city of Newton on the theory that Your Honor is discussing, which is.
But I mean, I don't think it's uncontested, right, that the Commonwealth needed to keep the car, and the Commonwealth is the one who asked you to take the car and keep the car, right? Did Liberty, I understand you had this conversation with him where some agent said, well, you guys are cheap. You should be charging the government more, right? I'm not sure why we're not suing the government here.
Well, it's because Liberty Mutual was first the insurer for Mr. Castler, and second, the owner of the vehicle. And also, there was no contract between Tody's and the city of Newton.
That gets you the lien. I understand that's related to the lien. But I just don't see why we're not, I mean.
If Liberty Mutual, before the end of the criminal case, had said, oh, we don't want to incur any storage charges, send us the car, you couldn't have done it, correct? Because you were under an order from the police department and the DA's office to hold on to that car, and that wasn't released until after the criminal trial. Or do I have the facts mixed up?
Oh, you don't have the facts mixed up, Your Honor, at all. But what could have happened and what happened at Tody's was they continued to hold it, and this was the promissory estoppel argument that we started to talk about. They were under the impression that they would, in fact, be paid. And when they weren't paid at the end, and in the record, you'll see there's records, voluminous records about Liberty Mutual's notes. There's actually a note in which there's a conversation between Mr. Struzzulo and Mr. Donahue, in which Mr. Struzzulo says, well, you know, that's a lot of money for the storage charge. And Mr. Donahue says, well, wait a second, I talked this over with your claims person when he came in. He told me that he was going to pay the towing, and he did pay the towing.
Towing is different. I get the towing charge, but that's, we're talking about storage, which is.
I understand, Judge.
He's going to stand up and say you should have sued the state. Do you want to? You don't seem very interested in that. Do you want to address whether the statute provides for recovery against the Commonwealth?
I think that there are statutes which would have enabled the Commonwealth to enter into a contract with Tody's for preservation of the vehicle. Those were, and this is part of our detriment argument, those were not investigated by Tody's because they were of the belief that the storage would be paid by Liberty Mutual. And I'll point to this, Judge. This is within the record. This is when Liberty Mutual, in fact, paid the towing. At the same time, there's a conversation between Mr. Matuhu and Mr. Donahue. And at that same moment, there's this conversation that's alluded to in the record about this whole issue of storage. And after the fact, Mr. Donahue does what he says he was going to do. He sent
But
the
how
towing bill.
can you have detrimental reliance when you're under an order to keep it there? So irrespective of whether or not somebody from Liberty, some appraiser said to you, it said to Tody's, we'll cover it. That's not the reason why you continue to hold it. You continue to hold it because the city of Newton said, and the Middlesex prosecutor said, keep this.
But it didn't, I agree with you, Judge, but it didn't have to necessarily be kept at Tody's. It could have been kept in a indoor, secure
Does
storage
Tody's have a
facility.
financially beneficial relationship with the city of Newton when it provides these kind of services at the behest of the police department?
They are the only tower in 2016 and to the present that tows vehicles at the request of the city of Newton.
So it's in the financial interest of your client to continue that relationship without going after any statutory provisions it may have.
I would say, Judge, and Mr. Donahue testified to this, they do the towing for the city of Newton. Most of the time, the vehicles are insured. When the vehicles are not insured, Tody's does not pursue the owner of the vehicle if it doesn't have insurance. That the custom and practice at Tody's has always been that. They've been in a business relationship with Newton for the last several decades into the 60s. But getting back to the point that I was making about the reliance, and this is to your point, Judge, after Tody's got this check that was sent to them by Liberty Mutual for the towing, this is in the handwriting, I brought the original, this is in the handwriting of Mr. Donahue. This is the invoice for the towing, but he writes underneath it, payment for towing and recovery, storage to be paid when car released per Liberty appraiser. So I agree with you that there were other mechanisms that could have been undertaken in order to have somebody else take over the storage of the vehicle. But in this case, and this gets back to, and I think, frankly, our strongest argument is the promissory estoppel argument. That is that Liberty Mutual's representative went to Tody's. When he went there, and after he went there, he filled out a form. On the form, it talks about towing and storage.
Counsel, let me see if there are any further questions. Anything further? Thank you.
Okay. Thank you very much for your time. Appreciate it.
Attorney Gallagher.
Thank you. May it please the court, Owen Gallagher, and with me is Cara Lazarev for Liberty Mutual. Obviously, Liberty Mutual has a different take on this than Tody's, but to begin with, I'd like to start with...
Often that creates lawsuits.
It does. The Liberty Mutual, one of the statements my brother made was that there was nothing in the record about the fact that Liberty Mutual made a tender. And that's a critical point, because actually in the record, it is there. What happened was, on September 28th is when the district attorney went public with Mr. Kassler's vehicles report, stating on the record and in public, to the newspapers, that in fact they had conducted a forensic examination of the vehicle by technicians from Volkswagen and from an independent mechanic, and they had no reason to believe that the vehicle had any defect whatsoever. The next day, in the notes, there's a reference to another disclosure from the DA's office that the technician from Volkswagen had found that the accelerator was down to the 94th percentile, that the speed when the engine stopped was between 47 and 52 miles per hour. Mr. Kassler had driven right through two vehicles into the sweet potatoes and killing 2 people and injuring 7 more. Liberty Mutual, as Your Honor pointed out, had a $500,000 policy. The damages in this case far exceeded $500,000. The property damage, where he had a $250,000 property damage, was over $600,000. He hit the
I
building.
think the question was, on what date did Liberty Mutual tender the policy limits? I understand they reserved the policy limits
Correct.
soon after the DA's office, but we all know reserving the limits is not the same as tendering the limits. Your brief refers repeatedly to tendering the policy. On what date did that
January
tender?
6, sorry, Ron, January 6, 2017, it's in the record at 284. It's in the claim notes, and what it states is they
But
obtained.
in the claim notes aren't going to show a tender.
The statement in the claims notes is that they had received home office approval, and it goes on to say that they had sent letters to all of the lawyers involved to set up a mediation to split the policy.
But didn't tender the policy. It reserved the policy, and in its head, it knew it was going to do it. What in your tendering a policy has a technical meaning?
Correct, Your Honor. But the actual letter that went out to the lawyers is not in the record, but as the record says, they sent letters to a lawyer saying, we want to have you all come into a mediation and split up the policy.
Sure.
Right,
We
so
will
at that
provide-
point, you had tendered the $500,000, and the question was whether Mediator Finn was going to distribute it to who and what the priorities were.
That's
But
correct.
Liberty Mutual was writing a check for $500,000.
They had reserved it, as you said, Your Honor, and they put it out. Once they put it out, I mean, they were under basically unfair claims practices. They're not taking it back. In fact, the original information obtained from the DA put them under 176D, saying you have to make a reasonable tender or settlement when liability is reasonably clear. On this case, with the DA's statements, this was more than reasonably clear.
So how does this, why does the date of tender matter with respect to the claims that are being made here?
Well, what happened from Tody's is their statements are that there was value in this vehicle. That if you look in the brief, it says the central issue is that Liberty Mutual had to keep this car because they had to do, for the benefit of their insured, an inspection because he had said that it accelerated twice. There was later evidence that came out that there was no basis for this. However, that's their position, which is you have to keep this. And as they say in their brief, right up until the time of mediation in 2019. And so, but Liberty Mutual, once they had decided to tender, the car was worthless. They had no need for it.
So it goes to promissory estoppel, or lack thereof.
It goes to quantum merit,
There were no,
maybe?
Or
it goes to, yes, it goes,
To benefit to Liberty Mutual.
there was no benefit to Liberty Mutual, and it's on the record that you don't need it.
So can we just speed forward to the period after the law enforcement has informed Liberty Mutual that they directly informed Liberty Mutual they no longer have a hold on the vehicle. Let's imagine that it actually was a valuable vehicle, more so than it is. It's not valuable, but if it was like a Bentley that was bent,
Correct.
at that point, there would be, it would be appropriate at that point for, if Liberty Mutual chose to keep it at Tody's, for Tody's to be paying pursuant to the statute, capped at $35 a day, et cetera. You agree with that?
I do, Your Honor. The January 31st was the date, 2019.
Correct. So
If Liberty Mutual, I'm sorry, Your Honor.
So I was getting to a further point, which is you're asking us to adopt a rule, I take it for all cases, that in quantum merit or unjust enrichment, you are limited, the recovery is limited to the value of the item. And so in this case, the item is worthless, right? But there could be cases, not only is it worthless to Liberty Mutual, it's also worthless to anyone. But you could have a situation, for example, where you have your grandmother's ring, and it's of tremendous sentimental value to you. Your grandmother was not wealthy. It is not actually worth much. But you put it in a bank box because it's important to you, and importantly, a thief might think it's valuable. So in that case, is recovery limited to, and then you stop paying, is recovery limited to the actual value of the ring, or should we think about what is the value of the service conferred, right? The bank only has X number of safe deposit boxes, they have a market value, and they were giving that to the person.
Well, that's voluntary, that's a voluntary contract. I mean, if Liberty Mutual said on January 31st, keep the car and we'll pay whatever rate, at that time he was charging $35 for another 2 weeks while we pick it up. We owe the money, there's no question about it. We're making a voluntary contract. The issue here is this vehicle immediately went into impoundment. And that's the area of law here that there just isn't any, which is once the police impound something, and in this case they actually put a search warrant, and as we quote the statute, it's under the control of the court.
But I'm talking about the period after that and how we value that, because you're saying we necessarily only look at the value of the item, and that how can storage services ever be worth more than the value of the item? And I'm asking, you're arguing that we don't look at all at the market value of the service provided. I mean, they've put in no evidence about the market value of service for car storage, but we're making a rule for all cases.
If I understand the question, you're saying, how could somebody say this was of more value to you, so you owe me more money?
Well, it's where you're asking us to say that the value of storage services is never more than the thing stored, right?
This is,
That's what Dine says.
No, we're not, Your Honor, because there's a Section 6B on a regular storage of a motor vehicle, to keep it in this context, has a fixed $35 maximum.
Yeah.
That would be the rate that would be there. The issue of what happens when, like in this case, where somebody suddenly comes back and says, no, you owe me money. We say we're not under that statute at all.
Understood, but so one of the amici cited this case, or the amicus cited this case, G4S, right? So that, I don't know if you had a chance to look at that case, but that's a construction case, right? And it was a quantum merit claim. And in G4S, the court decided, how are we going to say, to identify the value of the benefit conferred by a subcontractor? And what the court said in that case was, we're going to say the value is the labor that the subcontractor gave and the materials that the subcontractor provided, not what value was received by the recipient of those things. And I'm not suggesting at all that the assessment is the same in this context. That was obviously limited to the construction context. But I'm asking you to defend the rule that never could, the services here are worth zero because the car is worth zero, even though there's a statute saying you get $35 a day.
Well, I don't think we're saying that in this case is sui generis. But in the regular case involving storage, the storage, it's going to be initially under 6B. However, that has two references to statutes that are part of the whole. One is 255, Section 39A, and also 266, Section 29. They're both referenced in 6B. The mechanism for enforcement is, if somebody doesn't pay, is under 39A.
Well, except that the statute expressly, 6B expressly says nothing in this is eliminating, or I forget the exact word, but is preventing greater recovery as long as the rates are charged lawfully under the statute, correct? So that reserves the possibility of a common law action.
Yes, that's exactly what the remedy is. It's a common law action. Nobody in this case, we have never said Tody couldn't sue.
But there's a period after, once, I'm not talking about the period when it's on police hold, but there's a period that's shorter when it's not under a police hold. And we also have to decide whether there's any recovery for that period, correct?
Well, once Tody refused to release the vehicle, he was holding it for his own benefit to collect on the lien. So we have no liability for that period, in our opinion, because of the fact that it wasn't being held for our benefit at all. So,
Well, maybe we can just go through the chronology in a little bit more of a concrete way.
yes,
The conviction was on October 29th, 2018, correct? The conviction,
October 2018.
yeah, October 29th, 2018. Tody's then moved the car to its outdoor storage lot. They sent you a bill in February, on February 5th, 2019.
Correct.
And then you tendered the car in March 14th, 2019.
Correct.
Would you agree that between the period of conviction to the point when you tendered the car, you were on the hook for $35 a day storage fee?
I would not, Your Honor, for this
Why not?
reason. First off, the vehicle was still held by the police until January 31st. We were not given the authority to pick up the vehicle
Okay, so
until
from,
that time.
all right, so from
But after-
after the point when the police released it, until you tendered the car, you would agree that you were on the hook for $35 a day?
I don't think there's any issue on that. We
Okay.
can deal with that.
And do you know if that amount was greater or less than the value of the car as it was tendered?
The car was pretty much worthless by that time, so that would be more than.
So that would be more than the,
Equal, the last value, the original salvage value, which is what we would be, was 3,000. The last time we looked, it was under 1,000. So we're talking here probably, it's probably less than the salvage value if it's $1,000. We're talking about, what, a month and a half, 2 months?
I think it was about a month and a half,
Yeah,
$1,400 if you do the math.
In the indoor storage,
Pardon me?
in the fence storage.
Yes, $35.
Anything further?